Angelina Jolie y Brad Pitt se divorcian. Tras la conmoción que ha generado la ruptura de uno de los matrimonios más mediáticos del mundo del cine, Lori Howe, abogada especialista en casos de familia, nos explica qué va a ocurrir ahora con el patrimonio y la custodia de los 6 hijos de la pareja.
Mr. Pitt will have 30 days to file a response to the petition for dissolution. And then, most likely, if they're not already doing it, the attorneys will meet with each other and confer and see whether or not there are issues that they can resolve without going to court. If they're not able to do so, or one party believes that there's some emergency issues that need some immediate relief, then it may be that somebody will file a pleading with the court seeking that relief.
Ha sido la actriz quien ha presentado la petición de divorcio en Los Ángeles, a pesar de que su boda se celebró en Francia. Una demanda que se ajusta a los estándares habituales de la mayoría de demandas que se presentan en California.
She filed the standard petition for dissolution, citing irreconcilable differences, which is very normal, and that's typically what people cite as a grounds for divorce in California. And then also she's seeking, I saw, sole physical custody, but joint legal custody.
Jolie ha pedido la custodia física total. Sin embargo, en su petición se refleja la custodia legal conjunta. ¿Qué supone este tipo de custodia? ¿Por qué la ha pedido?
It's not uncommon that a person would seek sole physical custody in their initial filing. That doesn't mean that is what they will end up seeking if they resolve the case through settlement or in a courtroom. It may end up being joint physical custody, irregardless of what somebody asked for in their initial petition. This is a very mobile society, and it's not uncommon that you have people that live half the year in one location, half the year in another location, and have other homes that they go to for vacation. So as far as the fact that they do have other residences, that really won't play into the custody decision. It'll be a determination of the best interests of the minor children. And in California, typically, or at least locally, joint legal custody is preferred.
El sistema judicial norteamericano es público. ¿Será posible conocer todos los detalles de la sentencia o habrá secreto de sumario?
Courts aren't inclined to grant a motion for a sealing order. And the public has a right, it's a public court system, the public has a right to see what's been filed, it's all a public record. But for purposes of the safety and protection of the minor children, the court does sometimes issue a sealing order on that part of the file having to do with issues pertaining to the minor children.
Según las leyes de California, solo el patrimonio adquirido durante el tiempo que haya durado su unión debe ser repartido de forma igualitaria. Tal como sostiene la revista Forbes, la pareja ha acumulado hasta 555 millones de dólares desde que empezó su relación, mientras que la cifra se reduce a 118 desde que se casaron. ¿Cómo se repartirá la fortuna?
I would not doubt there would be a premarital agreement, but sometimes people don't have them. You know, the law protects parties' separate property that they had prior to marriage, and in this case, they weren't married that long. So the extent of what would be considered community property if they didn't have an agreement, it may be somewhat limited.
La pareja además tiene una fundación en común creada en 2006. ¿Qué podría ocurrir con ella?
Well, in regard to the foundation, they will most likely resolve that issue between them, and if they don't, then a court will make orders regarding who should take over the foundation, and it's usually the person who was more involved managing the foundation that would end up being awarded that asset.